Good morning and a warm welcome to today's webinar on the transposition status of the EU Whistleblowing Directive Part 4, as you can see it on the slide. So welcome in the name of EQS Group and our dear partners from KPMG Law. We are really happy to see you again here, or maybe for the first time. So some of you will know that this is a series of webinars that we've done over the past few weeks and months, looking at the EU directive and the state of transposition into national laws, into national legislation. I'm really glad to see so many participants. We had a huge number of registrants, and we also already have a large number of people being in the webinar from all across Europe and from many different industries. Welcome again to this webinar. And in the next 90 minutes, we will take a look together with our partners from KPMG on where we are, how far we've come, how far the member states have come in terms of implementing the directive. And as most of you will know, we are nearly 1 year after the directive coming into force, but we are still seeing quite some countries that are late, some that already now gain some experience because they already implemented nationally for at least a year. So it's a very diverse picture looking at the EU regarding this topic, and we have shed some more lights and learned a lot about the details on a per country base during this webinar. Before we start, maybe some technical hints for those who are new here, otherwise repeating for those who already joined one of our webinars in the past. So there's icons that help you to either enlarge or reduce the window of the webinar so that you can make yourself comfortable with the right size. You will find the question mark icon if you have any questions. We will see your questions coming in, so they will not be visible to every participant, but they will be visible to us as the speakers. And like usual, we'll take some of them up maybe in between as it fits, and then collect the rest for the FAQ sessions that we will do in the end again. The past occasions of this webinar series have shown that there were quite a number of really good questions and very interesting discussions. So whatever your plans are for today, please stay with us until the very end of the 90 minutes. Otherwise, you might be important the most exciting stuff. There's also download material available. We are happy if you provide feedbacks to us. And the question mark, by the way, if you are seeing any or running into any technical issues, for example, no audio, no video, slides not moving or whatever, please click there and our colleagues in the background will try to help you. All right, let's get right into it. And before I hand over to KPMG, let's start with a short poll question. This is always quite helpful also to get an idea who is in the audience today, and especially where you are looking at whistleblowing directive and implementation of the directive and implementation of whistleblowing in your organization. So let me click, and you should now be able to see the question. So the question that we are asking is, what is the status of implementation of the whistleblower directive / and or the national transpositions in your company or organization? So the options are: we already have a whistleblower system in place and fully meet the requirements. Or you might say, we have a whistleblower system in place, but we need to adjust it, improve it, enhance it, because we do not yet meet all requirements of the directive. Or you do have a whistleblower system, but you're waiting for the national legislation to be really sure what you need to do and implement. Or you might say, we do not know exactly if and how we have to implement a whistleblower system. So if we're affected by the directive and so on. So these are the options. Currently at nearly 50%, so I'll give it a short moment so that everyone has the chance to answer. So still a number of answers coming in, so we'll leave it for a few more seconds. Okay, still some answers. Maybe let's take 10 more seconds and then we'll continue and look at the results at your answers. All right, so let's take a look at the results and see how you voted. And this is really interesting to see. So I'm part of this webinar series from the first occasion on, and we've always asked this question in the beginning. And looking at the results, it's really interesting to see that more or less near to 60% of you are saying we have a whistleblower system in place and it meets the requirements of the directive. So this is a much higher share than what we had in the past, where we always were looking a little bit around 10% split maybe. So obviously there's been quite some progress, which is good. And it's good because transposition is moving forward. So a lot of things is happening. The directive is in place. The transposition is coming. So everybody who falls under the directive anyhow needs to act. And obviously, quite a lot have done this. So this is why it's moving forward. And if we take the first two together, then as you can see, this is beyond 80%. So 4 out of 5 are obviously quite well prepared already. And on the, let's say, lower end in terms of implementation, we only see 2% saying we do not yet know exactly if and how to implement a whistleblower system. So for you, we'll try to also make clear and give you some guidance maybe today so that you can answer the question if you have to, and then seek for how to implement the whistleblower system. All right, so with this, I would click to the next slide and then hand it over to our dear partners from KPMG Law. So Bernd Federmann is again in the webinar, and a lot of his colleagues from the different countries and markets speaking and reporting. So Bernd, would you want to take over? Happy welcome, a real pleasure to again do this webinar with you.
Thank you very much, Jens. And yes, welcome also to the audience from KPMG side. My name is Bernd Federmann, partner with KPMG Law in Germany with focus on compliance advice. Today, the colleagues of the KPMG Whistleblowing Network want to give you again an overview over the current status of transposition of this directive into national laws throughout this 27 member states, and the situation also first time in Switzerland. KPMG has a global network of more than 70 or nearly now 80 independent KPMG country offices that are specialized on legal and forensic advice on all topics around whistleblowing. And we work closely together with our alliance partner, EQS Group. So we can go to the next slide, please. The EU directive on the protection of whistleblowers requires all organizations with more than 50 employees as well as the public sector to set up an internal reporting channel and a case management system to report and process violations, especially of European law. Interesting to see that more than 50% have already a whistleblower system in place, as we saw. And the question, and only less than 15% have not done anything in this respect yet. Here you can see the agenda of today's webcast. The EU Whistleblowing Directive is expected to be largely implemented in the European member states in the course of this and the beginning of next year. Johanna Trautner and Nadine Kern will give a high-level overview over the situation in all the member states, where the directive is already transposed, where exists a draft law, and where nothing has happened so far. Andreas Brucksch will highlight the situation in Germany of importance, as also with the German Supply Chain Due Diligence Act, the so-called grievance mechanism, will be to be implemented from beginning of January the next year. Then we will have some deep dives into the situation of Belgium, done by Gert Kavenberg and Valerie van Grieken. We will have a look to Italy, done by Giulia Cantini. We will have a look into Spain, done by Almudena Quero Saiz. And we will have a look into Switzerland, which is not an EU member state, of course. However, it's touched in quite different ways also by the directive that is done by Gaurav Bhagwani. And then at the end, we will have a look at into the Netherlands, done by François Coppenon. At the end, EQS will present the system which is technically able to cover all these requirements. And that is done again by Jens Kressler. The colleagues will each shortly present themselves when starting their contribution. And the presentation will afterwards be sent to you up on request. We then can go to the next slide, please. The status of transposition of the EU Whistleblowing Directive varies across EU member states as indicated before. The status of November 22 is shown in this map. As you can see, 11 member states have already transposed the directive into national law. Only 2 countries are left which have even no draft law. The members of the global KPMG Whistleblowing Network have prepared a white paper with an overview of the current transposition status in each member state and advice on the local specifics. The edition November 22 will be published in the course of next week. Also, EQS has prepared a respective white paper, and KPMG is also happy to largely contribute to this, and there is an ongoing update in this respect. The details of the member state situation are now outlined by my colleagues, and I am happy to hand over to Johanna and to Nadine. Thank you. We can go to the next slide.
My name is Nadine Kern from KPMG Law in Germany, and I'm an employment law expert, and I'm currently involved in many projects to implement whistleblower systems in companies and groups. In the next few minutes, my colleague Johanna Trautner and I will give you, as Mr. Federmann has already mentioned, a brief overview of the implementation status of the EU countries, which our colleagues will not go into in detail at a later stage. We will start with the few countries that have already implemented the directive. The first one is Cyprus. In Cyprus, the directive was transposed into national law in February this year. In addition to the reporting topics of the directive, further reporting topics such as criminal offenses, including corruption, non-compliance with any legal obligations, violations imposing danger to security or health of a person have been added. Anonymous reporting of violation and reporting by email are permitted. And for small companies, the law does not have to be implemented until December next year. and the penalty for violations is up to 30,000 euros.
Hello, everybody. My name is Johanna Trautner. I'm a senior associate and lawyer at KPMG Law in Germany in the Stuttgart office. I joined KPMG Legal in 2018, and I'm a member in KPMG's legal practice group compliance and corporate criminal law. I'm happy to be able to participate in the webcast today and together with my colleague Nadine Kern to give you a brief and high-level overview of the implementation status. Let's have a look at Croatia. The directive has been transposed to national law in April 2022. The anonymous reporting is permitted. As per the Croatian law, it is prescribed only that persons who firstly made an anonymous report but were subsequently identified have the same protection as the whistleblower who immediately disclosed their identity. No additional clarifications are available. The reporting via email is permitted. Companies with between 50 and 2,049 employees could share resources when accepting applications of whistleblower reports and processing them under conditions stated in the Croatian law. There is no further clarification. There is whistleblower protection against retaliation. The whistleblower protection also applies to certain third parties linked to the whistleblower, such as colleagues or relatives. Monetary fines for not implementing the legal requirements are up to €4,050. There is no separate regulation on data protection. There are regulations regarding the employee participation by a trustworthy person of works council or trade union. Currently, there is no requirement to report an establishment and operation of a whistleblower system to any authority in Croatia. Next slide, please.
Next one is Denmark. Denmark has already transposed the directive and the national law is in force since June this year. For small businesses, a later implementation date applies. This is December 2023. Also, the Act allows a group to set up a shared whistleblower system which covers all member companies within the group. At the same time, the employer can fully or partly outsource the whistleblower unit tasks and whistleblower tool at an independent third party, such as lawyers, auditors, etc. Email reporting is not prohibited as a reporting channel and are processed the same way as reports made through other channels. The government has established a central reporting channel at the Danish Data Protection Agency website. Now let's have a look to France.
In France, the directive transposed to national law on February 16th, 2022. In March 2022, the law transposed was enacted in France. The law entered into force on the 1st of September this year. An organic law was also enacted in March 2022 to reinforce the role of the defender of rights. Those two laws were supplemented by two implementing decrees. The first decree was issued in April this year and appointed a deputy to the defender of rights who will be in charge of supporting whistleblowers. The second decree was in October. It provides further information on the collecting and processing of reports and sets the list of the external authorities which will be competent to receive external reports. There is whistleblower protection against retaliation. The civil fine for delaying or abusing practices is €60,000. Persons who discriminate against a whistleblower may be sentenced to a 3-year prison term and a fine of the amount of €45,000. The French law does not require companies to allow anonymous reporting, but it also does not prohibit it. The decree of October this year stated that the internal whistleblowing procedure must specify the follow-up that will be provided to those anonymous reports. Companies with less than 2,050 employees could join their procedure for collecting and processing reports. The decree from October this year clarifies the conditions, and companies with less than 2,050 employees will be able to combine their procedure for collecting and processing reports. Also, the decree of October this year clarifies the conditions for this pooling.
Okay, next slide, please. Let's have a look to Ireland and Greece. We will start with Ireland. Ireland has now also transposed the directive into national law in July this year. This Transposition Act is a significant expansion of the Irish Protected Disclosure Act 2014. For small businesses, the law will only take effect from December next year. Violations of purely national law do not fall within the scope of the Act. In addition, the personal scope of the law has been expanded and now also covers, for example, volunteers, board members, or shareholders. The Act does not contain provisions on the treatment of company group matters. Internal reporting channels and the disclosure process may be handled internally or by an external third party authorized by the employer. But the companies under 250 employees can share internal reporting systems. There is no specific allowance in relation to anonymous reporting. The penalty for violations is up to 250,000 euros. For natural persons, also imprisonment of up to 2 years is possible. And next one is Greece. In Greece, the law was voted on November 11th this year, and Greece has transposed the directive. The law is now in force. There are 2 different implementation dates. 6 months from the entry into force for public entities and private entities with more than 250 employees. 11th December 2023 for small private entities. It should be noted that all private companies must inform the Labor Inspectorate or the relevant supervisory body within 2 months of compliance. The law does not provide any requirements for design in a group structure. It is only provided that small entities might make use of the same officer for receiving or monitoring reports. Reporting topics are violations of EU law as specified in the Greek draft law, violations of EU's financial interests, and violations related to the internal market. The National Transparency Authority is appointed as the competent authority for external government reporting channels. Finally, there are a few exceptions with regard to the data protection. So next slide, please.
In Latvia, the directive transposed to national law in February this year. The Latvian legislator did not include an option to report anonymously. Thus, a private entity can allow anonymous reporting, but then the employees shall very clearly be notified that they will not have the protection provided by the law, and a full investigation may not be initiated. The email reporting is permitted, but it's only a channel to submit the report. The Latvian law does not specifically address subsidiaries. Managing the whistleblowing system as a group is allowed as long as it does not affect the independence, confidentiality, and personal data protection of processing the report. There's a fine for violation up to 7,000 euro. There's no separate regulation on data protection. The employee participation via employee representatives is allowed. The new Latvian law established bodies that can act as representatives of employees to protect their rights during the whistleblowing process. There is no obligation to notify an authority for the implementation of a whistleblowing system. In Lithuania, the directive transposed to national law and is in force since also in February this year. The transposition law largely follows the directive. Reporting topics are any violation of law in public interest as additional reporting topics. It is stated that private legal entities, other organizations, branches, regardless of the nature of the activities, with 50 or more employees must implement internal channels. A breach of the requirements set out in the Lithuanian law in a fine up to euro 4,000. The reporting via the anonymous reporting is not prohibited, but both the Lithuanian law and the bylaws are worded in a way that encourages non-anonymous reporting in order to grant the protection and support measures to the reporting persons. However, the Lithuanian law also covers respective measures for those who have provided information anonymously. The reporting via email is permitted. There is also whistleblower protection against retaliation. And there is no separate regulation on data protection, and there is no separate regulation on employee participation. Next slide, please.
In Portugal, the law was transposed in December last year. However, it did only enter into force on June this year. In addition to the reporting topics of the directive, violent and severely violent criminality, organized crime, and economic and final crime are additional reporting topics. Fines for violation may reach up to 250,000 euros. So let's have a look on Malta.
In Malta, the directive has been transposed to national law in December 2021. Violations of national law also fall within the scope of Malta law. However, it applies only to private companies with 50 or more employees. It also applies to each ministry of the government of Malta as an employer. Malta law does not establish fines for companies that do not implement the legal requirements or do not implement them sufficiently. Organizations in the private sector having more than 50 but up to 249 employees are allowed to share resources in terms of reports and necessary investigations. Every employee is required to have internal procedures in place for receiving and dealing with information about improper practices reported to have been committed within or by that organization. The Malta law does not contain provisions on the treatment of group matters, nor does it cater for the possibility of maintaining a central system on group level. Anonymous disclosures are not protected under Malta law. However, anonymous reports may be received and processed and taken in consideration in determining whether an improper practice has occurred. The reporting via email is not prohibited. The whistleblower protection against retaliation is stipulated. The Malta law extends the protection to facilities and third persons who are connected with the whistleblower. There is no separate regulation on data protection. There are no participation rights of employee representative bodies, and there's no obligation to notify an authority for the implementation of a whistleblower system. Next slide, please. In Sweden, the directive transposed to national law in December 2021. There are two different implementation dates, the July 2024 for public entities and private entities with 2,050 or more employees, and the December 2023 for private entities with 50 to 249 employees. The number of employees is calculated at the beginning of each calendar year. There is an extended wider scope than the directive has, because it includes the reports of public interest. Currently, many international companies in Sweden use joint whistleblower systems. The Swedish new Whistleblowing Act provides the possibility for this practice to continue, provided that each individual entity with 50 employees or more implements its own whistleblowing system for internal reports. Regarding anonymous reporting, the new Whistleblowing Act does not require companies to allow anonymous reporting, but it also does not prohibit it. There's whistleblower protection against retaliation. Whistleblower protection consists of there's whistleblower protection against retaliation. The Swedish new Whistleblowing Act includes participation rights of employee representative bodies, and the establishment and operation of a whistleblower system does not have to be reported to any authority. However, the Swedish Work Environment Authority has been appointed as a supervisory authority and must ensure that there is a system for reporting and follow-up that meets the requirements of the Swedish new Whistleblowing Act. Next slide, please.
Now we come to the member states where there is already a draft, but it has not been implemented or is in force. First one is Austria. In Austria, the directive has not been transposed. The law will enter into force one day after its publication. The law is expected to be published on December 22 this year. It remains to be seen whether this will happen. According to the draft bill, it appears that the Austrian whistleblower law will largely follow the regulations of the EU directive, with some exceptions. For example, companies with more than 250 employees have a transition period of 6 months from the date the law comes into force. In addition, corruption is another reporting topic. Also, private legal entities of every size are allowed to share internal reporting channels, and it's not stated whether a group-wide whistleblower system is acceptable to be used by all group companies. With regard to the design of the reporting channel, anonymous reports are possible, but do not have to be offered. The draft stipulates that the internal reporting channel is to be preferred to the external one. Finally, there are no sanctions for companies if the whistleblower system is not implemented. With regard to the data protection, personal data shall be retained for 30 years after the last processing. The next member state is Belgium. Our colleagues will report on this in detail later. So please, next slide.
Let's have a look at Bulgaria. Currently, the directive has not been transposed. There are 2 draft laws for transposition the directive into Bulgarian legislation submitted for discussions to the National Assembly of the Republic of Bulgaria. The second Bulgarian draft law and a memorandum were submitted in October this year by the Interim Council of Ministers of the Republic of Bulgaria. Both Bulgarian draft laws adopt the minimum standards for protection of persons reporting breaches of the European Union law and the national law in the areas provided for the whistleblowing directive, but also extend the protection as regards reporting of crimes of a general nature of which a whistleblower has become aware in connection with his or her work. There is whistleblower protection against retaliation. As per second Bulgarian draft law, proceedings are not initiated on anonymous reports. No separate regulation on data protection are stipulated, and there are no specific requirements regarding consultations with employee representatives and participation of the trade unions stipulated. General rules shall apply.
Let's have a look at the Czech Republic. In the Czech Republic, the directive is not transposed. There is currently a new draft bill available in the legislative process. According to the current wording of the draft, it is supposed to be active on July 2023. Information on possible unlawful act which has characteristics of a criminal offense or violations Czech law regulation are possible additional reporting topics. Also, an internal reporting system can be shared by entities which employed on average up to 249 employees in the preceding calendar quarter. Furthermore, a whistleblower must receive feedback within 30 days of their report being made, maximum 90 days. Finally, anonymous reports are not prohibited and the fines range from approx 800 euros up to approx 41,000 euros, or 5% of obligated entity net turnover of preceding accounting period. So next slide, please.
In Estonia, the directive has not yet been transposed. The first draft passed Parliament's first vote in January this year. According to the Estonian draft bill, the Estonian Whistleblower Protection Act was meant to be enforced from June this year. On May 2022, the Estonian Ministry of Justice submitted its opinion and proposed amendments to the Estonian draft bill. At the moment, no information has been published on when the Estonian draft bill will be taken up for a second reading in the Parliament. The draft bill largely follows the whistleblowing directive. Violation of national law and different offenses as additional reporting topics are contained. The new law will not apply on, for example, violations regarding employment relationship and state secrets. The anonymous reporting is permitted. The email reporting is also permitted. There is whistleblower protection against retaliation. The Estonian law does not foresee any participation right of employee representatives. Also, the establishment and operation of a whistleblower system does not have to be reported to any authority. Let's have a look at Finland.
In Finland, the directive is not transposed. The draft is in the parliamentary hearing and expected to become enforceable during the first quarter of 2023. There is a 3-month implementation period after entry into force. The bill draft allocates responsibility for the procurement and the maintenance of the progress, and the tool is assigned to the company, regardless of whether it is outsourced. Also, the draft contains a specific clause stating the national law does not limit the duty set out in the directive to protect whistleblowers. It is possible that anonymous messages is not provided, but a company can act only before the intervention of the public and the authorities if anonymous reporting is possible. Furthermore, centralized whistleblower systems are allowed, but the draft does not resolve issues emerging in centralized systems. For example, labor law, companies law, liability allocation, etc. Also, the draft specifically requires duly trained, independent, appointed case managers. Finally, there are no penalty for not implementing a whistleblower system, but in this case, there is a risk for the employer body losing the in the directive offered information advantage and a risk of discourage. So next slide, please.
Thank you very much, Nadine. My name is Andreas Probsch from KPMG Law in Germany, and I would like to briefly introduce you to the situation in Germany here. On July this year, the German cabinet approved a government draft of the Whistleblower Protection Act. The contents of the law are unfortunately currently still a subject of ongoing discussions. For example, in mid-October, there was an expert hearing in the legal committee of the German parliament. The draft still has to be approved by the German Federal Council and the German Parliament. There are no specific dates for this yet. According to our estimates, the law will not come into force before April 2023. Itself, the draft covers not only violations of the EU law, but also all violations that constitute criminal offenses. And whistleblowers must be able to choose between an internal and external reporting channel, and the companies must also point this out in their system. This is very special here in Germany, and as far as I know, it is also unique within the whole EU. The anonymous reporting should be permitted in Germany, and the companies between 50 and 249 employees may establish and operate a joint office for receiving hints and handling the cases. Under certain conditions, central internal reporting channel can even be set up at a group company within a group, regardless of the size of the company. And when implementing the system, works council participation rights are possible, and the provisions of data protection law must be observed. And the fines for violation are generally between 10,000 and 100,000 euro. And further important to know for Germany is that from January 2023, companies in Germany may be obliged to introduce a grievance mechanism in accordance with the Supply Chain Due Diligence Act here in Germany. And in this case, the individuals must be also able to report indications of human rights or environmental violations to an internal reporting office. And under certain conditions, such a grievance mechanism can also be well combined with the whistleblower system according to the Whistleblower Protection Act, set up in one system. Yes, and yeah, thank you very much. And let's go to the country Luxembourg.
Thank you, Andreas. In Luxembourg, the directive has not yet been transposed. The draft bill was published in January this year. Small businesses with 50 to 249 employees have a later implementation date, also in December next year. The draft bill is in line with the requirements of the directive. The draft law does not explicitly cover the treatment of company group matters. The draft law requires companies to allow anonymous reporting and allow electronic reporting. Consultation right of employee representative bodies during the transposition phase is foreseen. It is also foreseen that the Luxembourg authorities will check the appropriate establishment of the whistleblower system and may ask additional information in order to assess if the establishment has been done in accordance with the law. Next slide, please.
Let's have a look at Poland. In Poland, the directive is not transposed, but since August this year, a new version of the draft law exists. Now the draft is in a consultation process. The date of implementation is not predictable, but companies would have a maximum of 4 months for the date of publication to implement the law. For small companies, implementation is foreseen later, by December 2023. Private legal entities might amend additional reporting topics to other violations of national law and/or internal regulations and ethical standards. In principle, the Polish draft law does not provide for the possibility of anonymous internal or external reporting. Also, legal entities and public authorities can decide to consider anonymous reports. External reporting channels are foreseen. The draft does not contain provisions on the treatment of company group matters. Penalties for violations are according to the Polish Criminal Code. So let's have a look to Romania.
After missing the initial deadline and having discussed several versions of the transposition of the directive, Romania finally made key steps for implementing the legislation into national law. In July this year, the Romanian Parliament adopted the transposition law and sent it for promulgation. A group of deputies from the Parliament challenged this draft law to the Romanian Constitutional Court. However, within a short period of time, the case was dismissed and the law was declared to be constitutional. Even though the draft law was declared constitutional, the president did not enact the law and sent it back to the Parliament for another version. The Parliament has since made certain amendments and enrolled the draft bill for voting on the agenda in October this year. Nevertheless, the draft law did not enter into the voting process, and currently it is not clear on which date it will be voted by the Romanian Parliament. After the draft law is adopted by the Romanian Parliament, it will be sent again for promulgation to the President, who will have a legal term of 10 days to promulgate within the possibility to resend it to the Parliament. The adopted draft law follows the provisions of the directive in principle. Even though the new version of the law includes an option to make an anonymous report, the Romanian draft law hindered the possibility to make a fully anonymous report, as a whistleblower is still required to provide contact details, the quality of the person, and the professional context. Thus, indirectly prohibits anonymous reporting. Regarding the data protection requirements, the Romanian draft law contains a general provision stating that the processing of personal data shall be performed with the observance of the applicable laws, and that any data that is not necessary for the purpose of the processing shall be deleted immediately. Next slide, please.
In Slovakia, the draft law has not been transposed. The bill was presented to the parliament in May 2022. The transposition is not predictable. The draft is an amendment to an already existing law. In addition to the reporting topics of the directive, violations of national law will also be possible as an additional reporting topic. An anonymous reporting should not be prohibited. The draft does not contain provisions on the treatment of company group matters, and violation can be fined up to 200,000 euros. Let's have a look to Slovenia.
In Slovenia, the directive is also not yet transposed. The draft bill was published in December last year. In October this year, the government of the Republic of Slovenia adopted a decision with which it has determined the text of the relevant draft law and forwarded it to the legislative body, the National Assembly of the Republic of Slovenia, for the first reading. Small business have a later implementation date, December next year. The draft bill largely followed the directive. There is no further information on whether the law will lead to the need of independent processing of the whistleblower system and/or case management by the subsidiaries. At this point, there are no specific restrictions on centralized management of a whistleblowing system by an external provider. The current draft law states that anonymous reporting will not be reviewed. However, an anonymous whistleblower whose identity was subsequently disclosed is entitled to protection. There is a fine for violation up to 6,000 euros stipulated. The Slovenian draft law did not contain information on data protection and do special regulations for employee participation rights. Next slide, please.
Our colleagues will report about Spain and the Netherlands in detail later. So next slide, please.
There is now the cluster no draft law. Hungary, there is the directive not yet transposed, no official draft bill published yet. Currently, it's hardly anything can be predicted here based on limited information. As there's currently no available information regarding a draft law to transpose the directive, it is difficult to assess the applicability. In Hungary, there is a current law applicable, which includes provisions on whistleblowing procedures for public bodies and local government bodies. Under current applicable law, the anonymous reporting is omitted, and the email reporting is permitted. It could be expected that the draft law will also be applicable to state legal entities, departments, and other public corporations. There are no available draft laws concerning the contemplated amendments of the Hungarian Labour Code, which includes the participation rights of employee representatives. Currently, the operation of whistleblower system must be publicly available in public, but does not need to be reported to a government authority. And last but not least, we have Italy, and our colleague will report on this in detail later. Thank you very much. Next slide, please.
Good morning, everyone. My name is Valerie van Grieke, and I'm working in the corporate law, compliance law, and M&A team in KPMG Law Belgium. And today I'm here with my colleague Gert Kalmberg. We'll give you a short overview of the status of the transposition into Belgian law. So during the last webcast, which took place in May of this year, our inputs or overview was based on a preliminary draft of the Ministers of Councils. Back then, it was expected that the directive would be transposed into national law by July 2022. This timing was not met. So now recently on the 11th of October the 11th of October, the draft law was submitted to the Parliament. Now it is expected that the law will be voted by the Parliament by the end of 2022. The text states that the law will enter into force 2 months after the publication in the Belgian official Gazette. And according to our last communication with their contact person at the department, it is expected that the law will enter into force by beginning of March 2023, at least for the entities with over 249 workers. For the entities in between 50 and 249 workers, there will be additional time until the end of 2023. Now we will give you a short overview of some main content requirements. So as to the material scope, the Belgian draft law goes a bit further than what the directive provides. First, there are 2 additional areas where the directive provides for 10 categories of union law falling within the scope. The Belgian draft text has extended this to 2 additional areas, namely the fight against tax fraud and the fight against social fraud. And then there's another way in which the Belgian draft text goes a bit further, namely that a more open approach is used. Since the directive provides for per category of union law, there's a list of so-called union acts, so that these are regulations and directives related to each of the categories. The Belgian draft law does not limit this material scope to this overview. Then the obligation to set up the reporting channels on an internal level are not extended to the entities in the private sectors with less than 50 workers. As to the threshold, how should we calculate it? Here, the reference is made to the legislation on the social elections, with the difference that it is calculated on an entity level and not on a technical business unit level. So that would be an average number of employees over a certain period of time. Something we see in practice, a lot of clients ask the question, how should we organize, set up the system at a group level? And in this regard, the Belgian draft law is just referring actually to what is already stated in the directive. It is stated that only the entities in between 50 and 249 workers can share resources when it comes to the receipt of the reports and the investigation. So here probably we will have to seek the guidance of the European Commission from June 2021, which is rather strict. Then anonymous reports, the entities with over 249 workers, they should make sure that their internal reporting channels allow anonymous reports. And then finally, there's a lot of flexibility as to the type of procedure. It should either be oral or in written, but for the rest, there's not a lot of requirements in this regard. Only thing that's maybe important for the companies to take into account is that there should be the channels should be set up after a social consultation. So that's it for Belgium. Thank you.
Can you hear me now? Sorry. Hello, everyone. I'm Giulia Cantini.
Yes, we can hear you. Thank you. We can hear you.
Okay, sorry. I'm Giulia Cantini. I'm senior manager, legal manager of the governance and compliance KPMG office based in Italy. Our office is in Florence. For what concerns Italy, at the moment, we do not have a transposition law yet, and unfortunately, we do not have a preliminary draft. The first delegation law has expired, and a second delegation law has been approved in August 2022. And at the moment, we have a new deadline for the implementation of the new directive, that is the 10th December 2022. From a preliminary analysis of the delegation law, we can understand which will be most probably the focal point of the transposition law, that is to say, the protection of the whistleblower. In particular, the delegation law focuses the attention of the government on the need to amend, to adapt, and to harmonize all the existing legislation that we have in Italy concerning the whistleblowing matter, and both for private and public sector, because we already have a complex legislation system concerning whistleblowing at the moment. And there's also the need to strengthen the protection and the rights of the whistleblower. So the aim of the transposition law should be to assure the highest level of protection of the whistleblower. And I would say that it's crucial to assure an equal level of protection for whistleblowers belonging to both private and public sector. So this is one of the main tasks of the implementation law, because the risk is to be avoided. The risk to be avoided is that the whistleblowing system remains something that is not effective, something that that formally exists but is not effectively implemented. So the key element of the transposition law will be to define simple and easy way and procedure to guarantee the protection of the whistleblower, to guarantee the anonymity, and to avoid the risk of discrimination and retaliation from the companies to the whistleblower. In Italy, unfortunately, there is a general sense of mistrust in institution, and judicial proceedings have a long duration. So the big task of the transposition law will be probably to find out new ways to ensure protection of the whistleblowers. For example, setting external reporting channel, introducing a sanction for the violation, and also to adapt the existing measures to inspire confidence in this kind of system. So we are looking forward to receive the preliminary draft of the transposition law. We really hope that the new deadline of 10 December will be respected, and we can finally have a look on the new draft law. So thank you for your attention, and I leave the floor to my colleague.
Thank you so much. My name is Almudena Curero. I'm also Senior Manager of the Legal Compliance Department in Spain. And we would like to share with you some of the main points of the transposition of this whistleblowing protective directive in Spain. First of all, it's important to point out that in Spain, the European directive hasn't been transposed yet, but we are working in a preliminary draft, proyecto de ley, according to the Spanish denomination, that we estimate that could be finished and we can adopt a new law in April of the next year. According to this draft of the law, there are some difference or main difference regarding the directive. First of all, and in regard of the scope of the application, this draft extends the scope of the directive, including serious and very serious criminal, labor, and administrative offences. The draft will not apply to information affecting classified information, that it's very important, nor will it affect the obligations resulting from the duty of confidentiality of doctors, lawyers, as we are, or the state security forces and corps, and any other information when it established by specific regulations. This is very important from our point of view because it's these protective the protective measures could not be applied to all kind of information, specifically the confidential and classified information of these sectors. It is important to point out also that all public sector entities should be obliged to have an internal information system, regardless the number of inhabitants or employees. All Spanish public sector entities are obliged to have this internal channel. It is important also to state that this draft established the creation of an independent authority for the prosecution of whistleblowers attached to the Ministry of prosecution, and it's a mistake, the protection of the whistleblowers attached to the Ministry of Justice. This new public authority protecting whistleblowers could also have an external whistleblowing channel where people can use to inform of any irregularity besides the internal channel of its company. Anyone who commits an administrative offence and reported before the initiation of an investigation or a sanction procedure can benefit for the clemency program. This is very similar as the clemency programs in antitrust issues, and be exempt from the compliance with the sanction if certain requirements are met. Included the following, such as having previously ceased to commit the offence and identify the other offenders, cooperate through the investigation procedure, provide information, evidence, or data, and not disclose to third parties the information given and repair the damage caused. Regarding sanctions, it has to be also pointed out that fines could be considered very low, especially if you compare with other states, and could be up to 1 million. Regarding to data protection, we also must say that there are not specific data protection regime and all general provisions regarding this issue would be applied. Furthermore, it is also important to say that all Spanish companies who have 15 or more workers should be obliged to provide an internal information channel, different from the external whistleblowing channel that this independent authority of the to protect whistleblowers will also have. So that are the main features of the transposition of this directive in Spain.
Hi everybody, my name is Gaurav Bogonani. I'm from KPMG Zurich here in Switzerland. I'm a lawyer and also specialized in labor law. So as indicated in the invitation, I'm taking a short digression to Switzerland. Bernd has already indicated Switzerland is not a member of the European Union, so the EU whistleblowing directive is neither applicable nor does it need to be transposed into Swiss law. Therefore, the EU whistleblowing directive does not apply to Swiss-based companies. Nevertheless, the EU directive, of course, continues to apply to subsidiaries of, for example, Swiss-based companies in other EU countries, as long as the subsidiaries, of course, meet the respective thresholds regarding the employees. So as a Swiss headquarter group, if you have subsidiaries in the EU countries, those subsidiaries need to be compliant with the EU directive and the national laws in place at the country. So in Switzerland, there have been attempts to codify whistleblowing laws in the private sector in the past. Now, I think it's almost 14 years ago where the Federal Council kicked off this process by publishing its key message on whistleblowing for establishing laws. Thereafter, let's say in short, the Parliament had to examine and approve the respective bill. However, between 2014 and 2020, there was a lot of back and forth. The bill was amended, remanded for improvement, and finally rejected in 2020. Hence, for now, the implementation of whistleblowing laws in the private sector in Switzerland has failed. Given the long procedure and pretty clear rejection by our parliament, many people believe for the next few years, no similar project will pass in Switzerland, although there's a lot of pressure, and we'll get back to that. So what applies in Switzerland? Well, there are the general laws, Swiss law, that apply for the private sector here. And I just want to touch upon 3 selected topics. So from a Swiss corporate law point of view, an effective internal control process and appropriate organization of the risk management and compliance function as such is duly recommended to have implemented, which naturally always depends on the circumstances, such as size of business organization, field of industry, and associated risks. Although not explicitly stipulated, in practice, a well-functioning whistleblowing system can demonstrate good corporate governance and reduce risks of any type of misconduct from a corporate law/corporate governance perspective. Secondly, from a Swiss employment law perspective, employees are bound by their duty of loyalty, which entails a duty to confidentiality, of course. And in connection therewith, according to case law, employees must usually first report any misconduct internally to their employer, meaning, for example, their superior. And generally, if all means reporting internally have been exhausted, and if generally there's a public interest concern, for example, a criminal offense or so, the employee may then disclose a relevant issue to the authorities, for example, the district attorney. As a very last resort, if the authorities fail to take any action, it would be permissible to take the misconduct public. And additionally, under Swiss employment law, whistleblowers may be protected against dismissal or reprimands under Swiss employment law. So particularly, a termination notice issued to employees who acted in good faith in line with their corresponding rights and duties could be deemed abusive and unlawful, depending on the circumstances. So if you don't have any whistleblowing policy in place, there might be a risk the employee chooses to report misconduct outside the organization, and that can escalate quite quickly. Further, from a Swiss criminal law perspective, the disclosure of business and fabrication secrets in breach of any statutory or contractual obligations, if someone files charges, is a punishable criminal offense. Due to this criminal risk, which could be inherent, reporting an issue could also become an issue for the whistleblower itself, because they might be disclosing business secret and fabrication secrets in connection with the report. So they might be punishable under that. Additionally, and this will be interesting maybe for a group of companies operating internationally, is under Swiss criminal laws, if somebody makes fabrication and or business secrets available to a foreign governmental body, foreign organization, or a private company, they also may face criminal charges, often so-called economic espionage. Due to such criminal risk, which could, for example, apply if someone transfers a report containing business secrets to a governmental body abroad, meaning not in Switzerland, or perhaps even a centralized reporting body at a group company abroad. Swiss companies often, for that reason, to mitigate that risk, even if a somewhat harmonized whistleblowing policy exists within an internationally operating group, like to establish a local reporting body for Switzerland specifically. So as you can see, the non-establishment of a whistleblowing system can cause uncertainty, risks, and the business and risk for potential whistleblowers themselves. I'll keep this short for the public sector, but in the public sector, there are certain whistleblowing laws, and they require or enable employees to report misconduct with designated reporting bodies. Often it's associated with crimes or misdemeanors that have been discovered in the course of the official activity, meaning in the work, and also there are protections in place that there should be no detriment to the reporting employee as long as they acted in good faith. Hence, in contrast to the private sector, there are some laws in place in the public sector. And as I indicated initially, Switzerland has been criticized for its lack of whistleblowing laws, considering its international business ties, especially since Switzerland continues to play an important role in enforcing foreign bribery. So they have gotten a lot of pressures from abroad. Despite all this, many internationally operating companies have whistleblowing policies in place. The University of Applied Science of the Canton of Graubünden, in cooperation with AQS, published their Whistleblowing Report 2021, in which namely several Swiss-based companies had to provide answers to several questions to the whistleblowing policies. And I just want to touch upon 3 points here. So the majority of the Swiss-based companies have some form of whistleblowing system, be it in terms of you can report to the CCO, there's some regulations in the code of conduct, or you have a formal reporting body. Obviously, the detail and protection varies depending on the company and the respective policy or program or indication, but for some companies, technically, it would rather be more just a simple reporting system than a proper whistleblowing system. Further, if they have won more than 50%, having a whistleblowing policy at least covered one minimum standard of the EU whistleblowing directive, which might look good on paper, but according to the authors of the report, 1 to 4 guarantees covered is still deemed insufficient. So only about 30% back in the time, the participating Swiss firms fulfilled 4 or more minimum guarantees, and only 6% about all of them. And last but not least, a little not that much surprising, larger Swiss-based companies were better prepared than small and mid-sized companies. That was it for Switzerland. Thank you.
Yeah, thank you. And then we're going back to the European Union again with the Netherlands. I'm François Coppenol. Contrary to what my name suggests, I'm a Dutch corporate lawyer based in Amsterdam and a partner with the KPMG legal team in the Netherlands. As we are implementing the directive in the Netherlands, a lot of what is happening and what is in the draft legislation in the Netherlands has already been presented by my colleagues. So I will highlight the topics that we think are specifically Dutch and should be borne in mind, especially when doing business or having business in the Netherlands. As I said, we are still in the draft law phase. So currently the legislation is debated. Actually, it is quite heavily debated in the Dutch parliament. The next hearing is scheduled for December the 5th. And the main complaint of several parties is that the draft legislation is not going far enough. It should protect the employees that are whistleblowing better than the current draft legislation does. Note that we do have legislation in place. So currently there is already whistleblowing legislation in place in the Netherlands, albeit that is different from the draft law in several aspects. As we do expect the draft law either in amended form or as it currently lies to enter into force shortly, I will limit my observations to the draft legislation. And then coming to that, the main contents of the draft bill are the following. First, good to know, not only do we already have the legislation in place, again, albeit different, government employees and therefore government employers are already obliged to actually adhere along the spirit of the directive. But for the other companies with obviously the same thresholds, what defines a small company, we'll have to wait for the draft bill before they know for sure what they have to do. I think an important difference with some of the other countries implementing the legislation is that the draft bill in the Netherlands does not contain any fines. So obviously the draft bill will oblige companies that fall within the scope to implement whistleblowing channels and a reporting system. But if companies do not do that, they cannot be fined. They can only be ordered to actually do that. Although our expectation is that when you would fall under the scope of the legislation in the Netherlands, you will probably also have problems reporting on your ESG. You will have a discussion with your accountant, etc., if you are under the obligation to implement and you have not done so. Netherlands is quite relaxed whether you can do that on a group level or need to do that on individual companies. There is no specific legislation, so our current position is that it's also something that can be done centrally. Of course, every company in the group should adhere to the rules. There will be several, almost 10 external reporting channels within the government. Think competition authority, think central bank, etc. And I think that sums up the main contents of the draft bill. Quickly discussing the special requirements on the reporting system. The current legislation in draft does not contain a very specific procedure for that. It has more of an overall idea that there should be a reporting system, and it gives only a limited number of suggestions. Well, it's not suggestions. You actually have to have the reporting system include those items. But they're also quite broad, so there must be procedures in place. There must be a list of channels available. It must be explicitly mentioned that the employee is allowed, so that's before actually doing the whistleblowing, to consult with an external advisor whether or not it is actually something to whistleblow about. There should be procedures for internal reporting, etc., etc., and there should be a register. Anonymous reporting is not currently, but that is one of the points of debate, implemented as such in the draft legislation. And the same goes for email as a reporting channel. Email is not prohibited as a reporting channel in the Netherlands, but it's also not something that is specifically addressed in the draft bill. Then, in terms of protection of the whistleblowers, again, a hot topic of debate in the Netherlands. The main protection would be that the employer is not allowed to take any action against the whistleblower or do something in terms of the employment relationship just because of the fact that an employee is a whistleblower. Obviously, it's more detailed than that, but I think that's the general scope. And as said, some parties in the Netherlands think that is not enough. Other legal requirements in the Netherlands relate to the more formalities. So you have to include the Works Council in the whole process. I think no surprise there. Obviously, it does something with non-disclosure clauses in employment contracts. And I think going back to the no fines observation I made earlier, you can actually enforce with the court the obligation to implement a whistleblowing system. But truth be told, it makes probably more sense if you have an actual case on your hands that someone will just do the whistleblowing instead of first going to the process of asking to implement a system. And I think a last point, obviously also a very important topic in these times, is the data protection. Some countries have specific rules for that in the whistleblowing legislation. In the Netherlands, currently there are none. So it would just follow the normal rules of data protection as laid down in the directive in that respect. So hopefully that gives an overview of the differences in the Netherlands in respect, relative to other countries, as well as the most important points of the transposition of the directive in the Netherlands. Thanks.
Yeah, thank you very much. And let me maybe take over here at this point, if allowed. So thanks to all the speakers, all the experts from our dear alliance partners at KPMG Law, KPMG. I think this was, again, valuable information, and we've really seen a lot of questions, a lot of comments in the chat. So obviously, a lot of the information provided today was information that answered open questions that many of you had, and I think we all share the impression that it's still kind of a not fully clear situation, also because of the different stages of implementation across the member states and some contradictory implementations to some aspects. So with regards to the time, what I would propose to do is that we more or less skip the part in terms of the system presentation. Let me just maybe mention three short aspects. So the one thing is that we've seen in the poll at the very beginning that a lot of you already have implemented whistleblowing solutions, and looking at the participants list, I know that the vast majority is obviously also using solutions from EQS Group, might be Integrity Line, might be the BKMS solutions, but no matter which one it is, to answer one question that appeared several times, yes, the solutions that we offer are fully compliant to the requirements of the directive and all the national legislations as well, as far as they are known or already in place. So whenever you have questions, whenever you want to talk about details, how to adopt the solution you already have from us to requirements for a certain member state after the directive has been transposed, please talk to your contacts at EQS. We're happy to help you and to serve you. If all agree, and I assume this is the case, I would actually like to then rather move over to the FAQ part, because we have a number of, I think, really interesting, good questions that we should cover. Bernd, are you available that we can maybe start this?
Yes, Jens, I'm available, and I think the colleagues are also available, so you can start.
Wonderful. Okay, so maybe before we start with the first question, two short hints. On the one hand, there were a number of questions coming in about can we receive the slides? We are clearly keeping your questions and make sure that we receive them afterwards, so no worries about that. And then there have been a number of questions that are really quite specific to a certain member state, to a certain detail of a member state's draft law, where we decided to keep them outside of this FAQ session because we have really a broad audience here, and to make sure that we're not boring people and that we focus on the aspects that are relevant for most of you, at least. So let's maybe start with an easy one, a question that comes up from time to time and also did today, Bernd. Are we counting heads or are we counting FTE when it's about the thresholds?
Yeah, it's according to the situation in the whistleblowing law, also the Supply Chain Due Diligence Act concerning always people. You don't count FTE, you count the people. So it's the persons, the number of persons working in the respective entity, which is of relevance. And one interesting thing in this respect, if you count the people, we have in Germany the Supply Chain Due Diligence Act, where subsidiaries and the people in the subsidiaries under certain circumstances are counted also on the mother company side. Yeah, so that is not the case in terms of whistleblowing systems. There you count the people, legal entity per legal entity.
Mm-hmm. Thank you very much for this one. So another one we got, I think that's an easy one probably. The question was about the fines that are defined in the transpositions. that we have so far, or as far as we understand the draft. And the concrete question is, will there be fines also for executives or employees of the company if they try to disclose the identity of the whistleblower? I personally would say clearly yes, but do you agree?
Yes, I agree. That is not just on basis of the whistleblowing law, but also on basis of data privacy law already now the case, irrespective of transposition of the whistleblowing laws. And in addition, with regard to the whistleblowing laws in Germany, for example, this would be a severe violation of the law with really significant fines posed on it.
Wonderful. Then let's move on to the next one. The next question is about email reporting. So in your reports across the different member states, we've seen in some countries that there is a specific mention of email reporting is allowed, is permitted. And the question that came was quite interesting. So someone was asking if email reporting would not be a violation of Article 9 number 1 of the directive in itself, because it would not ensure that non-authorized people can access the content of a report.
That's a very interesting question. And so we see different countries handling email not as a proper way to report. However, the Commission does not see this in this way. And there are explicit countries which allow email reporting. So out of the directive, it is not absolutely clear that this is not allowed. However, and you can put it a little bit more on a technical view, we commend it to have a system-based solution without email communication, as there are many difficulties with email communication, also with regard to data privacy law.
Thank you very much. Maybe let me just add a short comment from a provider perspective. So what we can definitely say is there is no 100% safe way looking at email to really ensure that unauthorized people cannot access the content, right? So your IT department will be involved, and there will always be ways for people to access content of whistleblowing reports when using email. This is different with technical solutions like those that we provide that are just technically structured completely different, and where it's really ensured and also certified and proven that even as we as a provider are not able to access the content of the report. So it sounds like a detail. It's going to be probably an issue if identity of whistleblowers is disclosed and investigations start to find out how this could happen. And then it might turn out that it was an email system and that it was not secure enough. So we would definitely not recommend it. At least not if you, when communicating the different channels of your whistleblowing scheme, so you might offer email, but you need to be transparent in communication, right? So you should point out that using email would not guarantee anonymity and cannot 100% ensure confidentiality, but it's up to the whistleblower to decide to still use it. If you communicate it properly, then you can still offer it as an additional channel. Okay, then we have another one that's probably a rather easy one. So slides are jumping. I don't know. I'm not touching anything, but doesn't matter. Whoever it is, please don't touch anything. So next question was about the follow-up to the whistleblower foreseen in the directive and also the national transposition. So feedback to the whistleblower after submitting the report. Dan, can you help us to remind us
there are
deadline
certain deadlines. They are in the directive that is very clear. 7 days after submitting the hint you need to have, and 3 months after handling the case, you have to inform the whistleblower what is going on. And that has to be qualified information, not just that the case is handled. That is not so easy how the content has to be provided, as there are also legal positions of that other persons concerned in the case, so not so easy. And with regard to the Supply Chain Due Diligence Act, Germany and in future Europe, you have the grievance mechanism, and there all also are certain time frames when you have to get back to those people who make the hints.
Thank you very much. We are 1 minute after 12, but I would actually allow us, and Bernd, if that's okay for you, maybe 3-4 more minutes, if that's okay?
Yes, perhaps we have some questions specific for the people or for the countries we have here.
For example, we could take a look at France. There was a question regarding the French law.
I think we don't have a French colleague here in the call.
No. Yeah, that's true. The other questions for the single countries are very much related to where certain drafts or transposition laws can be found. So looking for the sources of the original documents. So I would probably leave this off. And we have 2 very concrete questions.
That is perhaps a point when we publish our white paper. There you have the information per country, and there also the links are contained.
Very good hint, because this will answer a number of questions that we had in one go. Thanks for that. Let's take a quick look to the question of central and decentralized setups. This is anyhow one of the most discussed questions, because it's handled differently from member state to member state. One question that I really found quite interesting was in those member states that would allow that would require decentral reporting systems. Does this also then mean that investigations need to be handled and done locally? Or would it be sufficient if you have someone receiving the report and communicating with the whistleblower, but you would be free to decide for an external investigator, even from another country or entity, probably?
Yeah, very interesting question. You can provide, of course, or get help for internal investigations in cases. That is clear. However, it has all been organized within the local entity, and that is the difference from the centralized systems, where you can put all these topics to the central group company. Yeah, that is the difference. However, in parts you can get help, of course, from external parties. And you have to see difference. The European Commission makes a difference. Third party cannot be a group company. However, it is allowed to put topics to third parties, external third parties, under certain circumstances. That's allowed.
I have an add-on question to this one. So we just heard what you said about who would do the investigation, how this can be organized. What about visibility? So in a country where you have a decentralized setup, would still the central, the headquarter compliance department be allowed to see what's going on? So to probably have access to reports in the decentral system?
That's connected with this respect. In principle, not. despite the fact the violation has importance also for the whole group. Yeah, so that is the differentiation which rectifies then the information of the group also. Yeah, but you have always the argumentation from the whistleblowing perspective, from the whistleblower perspective. That is the position of the EU in this respect. So, and the details, they depend from country to country, how they are organized in the national laws, of course.
Okay, wonderful. So maybe let's then close today's session with one more question. In countries where the sharing of resources is allowed, which is related to the smaller 50 to 249 employee entities, typically, are there any formal requirements how this needs to be agreed between the sharing entities? Or would it be sufficient if I just, let's say, publish this within my whistleblowing policy?
You mean the agreement of between the different legal entities?
Yes, exactly.
Yeah, this has to be done by a service level agreement, and with respect to data privacy, also with data privacy agreements, that is necessary to be done. Yeah.
Mm-hmm. Okay. Wonderful. So I would say let's probably stop here for today, if that's okay. I can definitely promise that we'll do a follow-up on questions that are unanswered or very specific. Yeah. So Bernd, I think it's okay if we bring people in touch with your experts in the countries, if it's related
Absolutely.
to them. So that's, yeah. And I would like to thank once more our partners from KPMG Law very much. Bernd and the team, thanks a lot for your insights, for your expertise. Always a pleasure to do this with you. And to everyone in the audience, thanks for participating. Thanks for taking the time. Stay tuned. I am sure we can say that this topic will be with us for some time in the future still. So I'm quite convinced that even in maybe 6 or 9 months, we'll probably have similar webinars like this until we more or less check the boxes behind all the 27, but we'll see. Have a good year end, everybody, a good start to the next year if we don't hear or see us, and bye-bye.
Thank you, bye-bye.